Yeah, so welcome to our jurisprudence class. We are going to use the first couple of minutes to discuss the other aspects of legal positivism, which we haven't covered. And then after that, I will take maybe one or two presentations from some of the presentations. Move on. So let me share my screen now. So we have started discussion of legal positivism, and we have made the point that legal positivism is one of the dominant schools of jurisprudence or legal philosophy, and scholars which are often put under this label basically hold the view that the question of what is the law is a separate question from what the law ought to be. And for that matter, at every point in time, our focus, our emphasis should be on what is the law, the empirical or the factual existence of the law, rather than the normative dimension or the evaluative aspect of the law, as whether the law is good or bad, just or unjust. That should not be the concern of philosophers of the law or jurists for that matter. And we have noted how Jeremy Bentham, for example, spearheaded this thinking within Western jurisprudence or within Western legal philosophy, and how John Austin also came to add his own refinements. And we saw that essentially they're all talking about what we called the command theory or the imperative theory of law. And for them, as we have noted, basically hold the view that if we are talking about law, we must have the sovereign, and then the sovereign gives commands or orders or directives, and they are backed by sanctions or punishments. So that is what law is for them. And that is why Austin will be later on tell us that law is the command of the uncommanded sovereign, backed by coercion, as it were. And then we also made effort when we were in class to actually demonstrate how Austin, for example, reminded us that the way that we use law is very simplistic, in the sense that not all the instances in which we use the word law can actually fit the criterion or the proper acceptation or proper conceptualization of law within legal positivism, which is that law should be something issued by political superiors to political inferiors. That the political superior, for example, is also above the law that he posits or he put forward. And that is why he gave us a very elaborate analytical schema to try and point out those instances where we inappropriately use the word law. And if you remember, in that detailed analytical scheme or framework, Austin was able to map out for us the narrow situation in which we can properly call law, and all the other things, in his view, have pretensions of law, but they are not. So if you look at that, and we also look at the criticism of Austinian thoughts, especially the fact that the way he seeks to explain the nature of law gives a very, if you like, a limited or a narrow appreciation of law, because his explanation fits well the criminal law branch or dimension of law. So if you are talking about probably the criminal law, to large extent, you find significant truth in what John Austin actually suggested. We know very well that law is not just about criminal law. Law is about so many other areas, isn't it? And in the third year and fourth year of your legal studies, you appreciate this very well, that if you talk about contract, talk about tort, talk about succession law, wills, and so on, you cannot perfectly reduce that into the model of command backed by sanctions or punishment, as John Austin will have us to believe or understand. So let us keep that in mind. And of course, there's also a problem about the sovereignty, if you remember, that how he explains sovereignty is absolutely unrealistic. And we even attempted to test that against the backdrop of our own 1992 constitutional tablet, and how we were not able to perfectly fit Austin's understanding of sovereignty within how the framers of our constitution will point to as, if you like, the sovereign. Because as you noted, in Article 1 of the Constitution, we are told that sovereignty resides in the people of Ghana. And if that is so, how could all of us make laws, and then even all of us collectively are also subject to the law? Not even the case that collectively we make the law and it's only we as individuals who are bound by the law, and the collective we are not, because even the constitution or collectively as a sovereign, we actually have to follow the tenets of the constitution. If you look at Article 1, it makes that point. Yeah, so that is what we'll be discussing so far. So we move on to a very important contributor to legal positivism. That is H.L.A. Hart'S. I noticed someone has a sign up. So before we start discussion of Hart'S version of legal positivism, let me listen to that person. Yes, let's hear you. Somebody hand us up. Okay, that was an accident. Okay. Yeah, iPhone, your hand is up, speak. Yeah, you can mute yourself. Okay, I think it's not ready. Okay, so we want to discuss Hart'S concept of law. I've shared his work known as the concept of law, the full work in the PDF version. I have shared the work with you on your platform. Who was Hart to start with? Professor Hart was a British legal philosopher and professor or teacher of jurisprudence at Oxford University. And Hart'S rejected the command theory proposed by Austin and Bentham as providing a very narrow or very limited or restrictive understanding of legal positivism. So mind you, Hart'S is not saying that he's rejecting legal positivism, but he finds the explanation of legal positivism by Jeremy Bentham and John Austin as being inadequate. To Hart'S, law was more than just a command backed by sanctions. And the sovereign is not beyond the law, as legislators are subject to lawmaking procedures, which lay down rules to be followed by legislators. So, as we indicated, even when we attempted to explain the what we call the limitations of Austin's concept, we made that point that it's not all the time that law is just about command backed by sanction. And there are so many other important aspects of law which cannot be reduced to that. And again, if you are talking about the sovereign, Austin and to assent, Jeremy Bentham made the point that the sovereign is not, the sovereign is beyond the law. And that's why John Nelson will say that the sovereign is uncommanded. But in reality, whoever you call the sovereign is subject to law and also even to lawmaking procedures. We take even, if you go even into the British society, right? We know the British Constitution is unwritten in the sense that you don't have a single document, maybe like our own, like maybe 1992 Constitution, where you say that this is the Constitution of Britain, and their constitutional arrangement are actually scattered through various documents, conventions, and practices. Now, within even that context, that situation, the monarch there are certain settled conventions from the day of Magna Carta, the glorious revolution, and so on. So much so that certain things are well established, even if it's in convention, that the sovereign cannot just ignore them without incurring displeasure and probably rebellion by the subjects. Even there, having a monarch, you see how the monarch being the sovereign is not necessarily beyond the law. And then we come to our own backyard. If we take the Constitution, Article 1, Clause 1 says that the sovereignty of Ghana resides in the people of Ghana, in whose name and for whose welfare the powers of government are to be exercised in the manner and within the limits laid down in this Constitution, unquote. This Constitution shall be the supreme law of Ghana, and any other law found to be inconsistent with any provision of this Constitution shall, to the extent of the inconsistency, be void. Now, if we take Article 1 of our Constitution, trying to locate sovereignty in the people of Ghana, as the provision itself points out, Ghanaians are the repository of sovereignty. Nevertheless, the powers which Ghanaians have in making laws and all that are supposed to conform to the tenets, the requirements of the Constitution. So here you see that the sovereign, as a lawmaker, so to speak, are even subject to lawmaking procedures. So where is the uncommanded sovereign that Austin and Bentham are telling us about? And that is why Professor Hart'S sees law as a system of rules, and rather than just commands backed by sanctions, so a system of rules. And for that matter, Hart'S will concern himself with the manner, that is, the rules in which laws are promulgated, rather than who promulgates the law. So it's not so much about who makes the law, but how the laws are made. I mean, that is what is important. And Hart'S theory is based on the view that law is a social phenomenon which can only be understood and explained by references to the actual social practices of a community. So if you want to understand law, don't take law out of society. Try to understand law within the context of society, because it is the actual social practices of community which, by and large, give rise to law. And for that matter, if you wanted to understand law, you should also understand social practices. And this point, which Hart makes, will lead him to try and classify law in the primary rules and secondary rules, but we'll come to that in a minute. So to Hart, therefore, law is a social phenomenon, and this study involves recognition of the characteristics of the human condition. So social phenomena means that law is something concerned society, something about society. So you cannot think of law without appreciating society. So that is what it means by saying that law is a social phenomenon. Law is associated with people, it's associated with society. And okay. So there exist certain limitations of the human conditions. Later on, Hart will tell us, which also make it necessary for us to have rules in order that persons, property, and promises are adequately protected. So Hart makes the point that if you look at the human conditions, there are certain limitations of our situation as human beings. And for that matter, if you wanted to protect persons, if you wanted to protect property, and if you wanted to ensure that if people make promises, they'll keep those promises, then we need to have rules. And what are these limitations of the human condition? Hart will tell us. And of course, if you look at Hart, where the concept of law, it is towards the latter part, right? Just before you get just the postscript, the last chapter, that is where he makes these concessions. So Hart will, for example, say that human limitations which justify having rules so as to protect person, property, and promises are human vulnerability, that all human beings, we are, I wouldn't say free, we are vulnerable, that is, we are weak. We are susceptible to physical attacks. And because of that, there's a need for rules to protect. And then he also identified approximate equality. And that is to say that the strongest among us sleeps sometimes, thereby making him vulnerable. Human beings, we are not, we don't have the same strength, right? Some are more stronger, some are more resource than others. And then he also identified the fact that human beings, we have limited altruism. Altruism simply means selflessness, right? So the opposite of selflessness is selfishness. So human beings have limited altruism. That is to say that by and large, human beings, we don't have a strong tendency to look out for the welfare of others. And we are always trying to look at our own interests. And that is why I say that even if you are selfless at all, it is only to a limited extent. And we are more selfish. And because we are more selfish, there's a need for rules to develop so as to manage our various conflicting interests, because everybody will try and look out for that who concerns himself or herself. And obviously, conflicts are bound to occur in that respect. And if that is so, there's a need for rules to manage that. And again, Hart also observed that another important limitation of the human condition is limited resources. Resources are not unlimited. Resources are not in superabundance. Economists will tell us that we have a limited scarce resources, and then we have what they call like the insatiable wants. Human wants are insatiable, but our resources are what? Are limited. And because of that, there are obvious implications. Having limited resources, people being more stronger than others, so on and so forth, then we are bound to have some problems. So there's a need for rules to be there. And again, Hart also identified limited understanding and strength of will. Hart made the point that human beings, we don't have perfect knowledge. We don't have perfect understanding of things. Some, of course, may have more understanding than others and so on. Even those who just have more understanding, the understanding is not perfect. And for that matter, we cannot be trusted to cooperate with our fellow men or women. Cooperation is not automatic, and they flow from the various limitations of the human conditions, which we have actually outlined. Now, in the light of all these limitations of human condition, there's a need within society for a system of rules to be designed to protect persons' property and promises, as we have noted. And Hart will say that the rules are to be divided into two, primary rules of obligation and then secondary rules of obligation. And what does he mean by primary rules? Primary rules refer to those rules which prescribe the free use of violence, thefts, and deception to which human beings are tempted, but which must be repressed if their coexistence in close proximity to each other. In other words, primary rules are those rules which actually tell us what we need to do or what we don't have to do. So they actually, tell us the substantive duties, do's and what and don'ts. So those are the primary rules. And Hart'S will make the point that if we take any society, we definitely have these primary rules. We have rules which tell us what can be done, what cannot be done, and so on. And my screen is raising, just a minute. Yeah, so as I indicated, the primary rules are meant to tell us what we are supposed to do or what we are not supposed to do, and so on. And primary rules come first before other type of rules, which we call the secondary rules, will develop. So you say that in even a so-called primitive society, that is society which are not very sophisticated, you have primary rules which try to prescribe conduct or prescribe conduct, what you are supposed to do, what you are not supposed to do. But as society become more and more complex, primary rules which we originally had will not be enough, because there will be need to either change aspects of the primary rules to reflect changing needs, right? Let me give you an example. We didn't have what they call the internet. We got the internet, and having had the internet, other challenges develop. What are those challenges? We have people who use the internet or the cyberspace to do all manner of evil, all manner of bad things against others. Maybe fraud, stealing other people's data, and so on and so forth. Now, this is a new development. New challenges are presented. And we still need to be clear what people can do and what people cannot do, as far as, let's say, the cyberspace, the internet and all that is concerned. So we get the Cybersecurity Act, we get the Electronic Transactions Act, and so on and so forth. So here you notice that these obligations are recent, but they've had to develop in order to address the present world need. And that is why Hart makes the point that as society becomes more complex, they develop the need to change the primary rules to reflect some of the changing needs. There's also the need to adjudicate on its breach. In other words, if you have a primary rules who tell us that don't do this or don't do that, or you're supposed to do this that way or that way. Now, there should be arrangement for making determination as whether someone has complied with the obligation created by the primary rule, has not complied. So you need another aspect of rules, another aspect of law to adjudicate on the breach of the primary obligation. Just like, let's take football, because a lot of you understand soccer. You have a football or the soccer game, and you know how the game is supposed to be played. But there's a need for someone to preside over the game and tell whether someone has breached the rules of the game or has not breached the rules of the game. So the same thing applies to law from the point of view of rules, as Hart is developing, that it's not enough to have the primary rules telling us about the primary obligation, what they are supposed to do and what they are not supposed to do. There's also the need for us to have rules which enable us to determine whether someone has actually conducted himself in a manner which breach the primary rules or not. And again, it is also important to have another rule which tell us which rules are actually obligation rules. No, we've already made the point that the primary rules develop from, if you like, the social practices, customs, or what happens in society and so on. And over time, we come to know what they are supposed to do, what they're not supposed to do. But there should be a way of trying to recognize, right? Let's take Ghana, for example. Ghana, we have Article 11 of the 1992 Constitution. Now, Article 11 of the 1992 Constitution talk about sources of law. And what that means is that if anybody is making a claim that something is law in Ghana, then you must be able to trace it back to the sources, the list of sources in Article 11 of the 1992 Constitution. And if we look at Article 11, Clause 1 of the Constitution, it says that, and I quote, the laws of Ghana shall comprise A, this Constitution, B, enactment made by or under the authority of Parliament established by this Constitution, C, any orders, rules, and regulation made by any person or authority under a power conferred by this Constitution, D, the existing law, and E, the common law. So these are the sources of law in Ghana. And what that means is that if anybody try to assert anything as law, I should be able to subsume it under one of these heads. Is it the case that what the person is asserting as law, is it a constitutional provision? In which case it's under the Constitution direct, or is it a legislative provision as in from Act of Parliament? Can I trace it to any Act of Parliament? Or is it under delegated legislation? Maybe there's an Act of Parliament and then delegated legislation was made under that. And for that matter, this is being asserted as law. Or is it coming from the common law, a judge-made law, case law? Or is it customary law? So therefore, Article 11, for example, help us to also recognize that which form part of the laws of Ghana. And that is why Hart'S says that apart from the primary rules, you also need secondary rules. And the secondary rules are of three kinds. We have rules of change. That rules of change as in the rules which help us to know when the primary rules have changed or we have added to the primary rules. Rules of adjudication, that is rules which enable us to make a determination as whether someone has complied with or someone has not complied with the primary rules. And then we also have rules of recognition. That is the rules which enable us to determine whether any rule which is laying claim to be part of, if we like, the laws of the system is actually part of it, and so on and so forth. So how to make the point that in order to have a valid and a working legal system, we need intersection of primary and secondary rules. So you can't have a full-fledged legal system when you have only primary rules. You need secondary rules as well. So the two must work together. So in every society where you want to recognize a legal system, we should see these two major categories of rules, the primary rules and then the secondary rules. And that is why I had to make the point that there must be a system of valid obligation rules in accordance with the legal system's ultimate criteria of validity, which are generally obeyed by a majority of members of the community. In other words, we should have a certain framework, a certain system, or yardstick, right? Yardstick, on basis of which we make a determination as to whether a particular rule, which is postulated or which is put forward by anybody, is actually one which is recognized as forming part of the corpus of rules, the body of laws within the system. So you need that system of ultimate criteria of validity. And that is why if you take the Constitution of Ghana, right, Article 2 of the Constitution, which says that, Article 2 talks about, Article 1, Clause 2 talk about the supremacy of the Constitution. Article 2 talks about the fact that if anything contravenes the Constitution or is inconsistent with it, then you could go to Supreme Court for declaration to be made to that effect. So what that means is that as far as Ghana is concerned, the ultimate criteria of validity is that whatever you are calling law must agree with the Constitution. Very important. And again, those who administer the affairs of the community must accept, in addition to the valid obligation rules, the rules of change, adjudication, and recognition. So you take our courts, you take government officials and the various personnel within governmental arrangement into account, and the point is being made that all of them must actually know how and when we can say that there have been addition to the rules of obligation, or there have been some subtraction, like changes to it. And in terms of our adjudication too, now Ghana, for example, we have the Courts Act, right? We have the Courts Act at 459, which elaborates on the provision of the Constitution in Chapter 11. The Chapter 11 of the Constitution is on the judiciary. So when it comes to, let's say, adjudication and so on, we should be able to find out the things in the courts are the things in the Constitution of the judiciary, because they provide the arrangements in terms of the courts. You know, right? How you have like a proper court in which someone can go there and make a claim as whether a person has conducted himself in a way which, for example, breach the person's primary obligation in one way or the other. You must have like a properly set up court. How do you know they have a properly set up court? We have to go to the constitutional provision on the judiciary. We have to go to the Courts Act, and then we know that. And not only that, even it's not anybody at all who can sit as a judge to adjudicate a case. The person must fall within a certain criteria prescribed by the Constitution, prescribed by the Courts Act. And not only that, you cannot just go to court and just raise up your hand and tell the judge that you have a case and start talking. No, you know, we have a whole elaborate system, what we call like the rules of court, which you must follow, depending upon the type of case. Then there's a procedure regarding how you actually present the case, whether you are going to use a writ, you're going to use a petition, whether it's going to be just a criminal summons, and so on and so forth. And even when you go to court and you are trying to bring proofs that the way and manner someone behaved actually breach the primary obligation that he has, how you even bring that proof is also governed by law. So we have what they call like the Evidence Act, or the Law of Evidence, which will let us know what type of evidence will be accepted, what type of evidence will not be accepted, what is the probative value, what is the weight to be attached to evidence, and all that. So you notice that all these are matters of rules, but they are rules playing a distinct function. They are rules which are not end in themselves. They are not end in themselves that if you take the law of evidence and so on, the law of evidence, for example, or the Evidence Act per se, does not actually establish any substantive interest or right. But it helps us to know whether someone behaved in a manner which violated your substantive interest or right, which violated obligation that he owes to you, as it were. Or we take like the Courts Act, for example. The Courts Act per se does not do anything for you in terms of any interest you have or any right. But then it is, if you like, an accessory, right? Just as you have your phone. You have your phone, and you have the the accessories which go with it. The accessories themselves are not needed for their own sake, but for you to meaningfully enjoy, if you like, the phone or the computer and so on, those accessories are what are needed, if you like. And that is why we call this type of law, we call them the adjectival law, adjectival, or the procedural law, as it were. So maybe let us look a little bit more closer into the various things Hart is talking about as the rules. So as we noted, Hart sees law as a system of rules, right? Not just commands. And these rules, he told us, are based upon social practices. So they are social rules, if you like. And so he identifies what we call social conventions, right? So social conventions in Hart's concept of law are rules relating to morals, games, like games, for example, like you're playing football, we have rules, isn't it? You cannot physically attack someone. That will incur automatic penalty shot against you and a red card and so on. All those rules that you know, or boxing, or Scrabble, or chess. All these games have got rules. So those rules are not the rules that we are talking about for purposes of constituting law. And that is why Hart says that those rules are social conventions. They are social conventions or appropriate behavior in place of worship. If you go to mosque, for example, let's say our brothers and sisters who are Muslim, Assalamu alaikum. If you take them, for example, you go to the mosque, you cannot just do anything that you like, right? You can't go to mosque and you are not properly dressed. You wear mini, what they call a mini skirt or just anything like that. That is not appropriate behavior in a place of worship. Christians, you can't go to church and then you are playing phone games or you are watching pornography on your phone or your tablet or anything. That is not appropriate behavior in a place of worship. And you notice that even dressing, Sunday, for example, you go to church and you are wearing, let's say that you are sportswear, like maybe like a dress you wear for going to do gym or athletics. Nobody will actually sack you, but when you get there, you as a person, you will definitely feel odd. You feel odd, and in your mind, you definitely know that the way that you have presented yourself is actually violating certain ways of behaving, which everybody in the society or community expect that you behave when you go to a place of worship. And so these, Hart will say, are social conventions. And then he also identified another category of social rules, which he called rules constituting obligations. Rules constituting obligation. And what are these rules? These rules, according to Hart'S, what they call, like, they give rise to the valid obligation rules. And he terms them that the legal rules, right, or the law. So what he's trying to say is that he said that law is actually a social phenomenon, yes, but he is quick to point out that we have two categories, right, of these social rules, the social conventions, like the example that we'll be given. And then we also have another aspect of social rules known as, if you like, the valid obligation rules. And for him, those are the things which constitute legal rules, and for that matter, the law. So it is the valid obligation rules, or those aspects of the social rules which give rise to obligations, which he identified or classified into two compartments. So we have like the primary rules, and then we have like the secondary rules. And the primary rules of obligation, as we have alluded to in the introductory, according to Hart'S, indicate what activity one must perform or abstain from, right? So the primary rules of the obligation will tell you what you can do or what you cannot do. So as we indicated, the primary rules prescribe maybe things like theft. You are not supposed, stealing, right? Dishonest appropriation and things like that, or deception, fraud, forgery, unlawful harm. All these are prescribed conducts, and the rules which prescribe them are part of the primary rules. And there are other vices too, which are also prescribed. And these vices, the way human beings are, Hart makes the point, and consistent with other scholars, that as a result of limitations in human condition, we are prone to vice or to do bad things. I don't want to sound scriptural, otherwise in Paul, in one of his letters, maybe the pastors here will remind us, in one of his letters to one of the churches, we say that the good that I want to do, I am not able to do, is the bad or that which I want to avoid, which I find myself doing or moving towards. So that also reinforces a Hart's observation that human beings are inclined to do bad things or vices, and that is why the primary rules are needed to actually control us. And the primary rules are the hallmark of the legal system of the very early stage of society, which Hart called primitive society. That is society which has not gone through sophisticated civilization. It's just at very elementary stage. So in those society, the typical rules that you have there are like the do's and the don'ts, as it were. And maybe if you come to our own African society in those days, one will argue that probably the rule which says that you cannot go to this farm, or you cannot fish, or you cannot do this, and so on and so forth. There are also, if you like, the example of the primary rules of obligation within that milieu. Now, as society becomes more and more complex, Hart noticed that 3 defects will be seen in the primary rules. As the society moves from just being primitive, being simple, to more complex or sophisticated society, you begin to notice certain defects in the primary rules. And these defects, which may be observed in the primary rules, are 3. 1, uncertainty. Now, as the society becomes more sophisticated or complex, you begin to see that there's a problem in trying to identify which rules are indeed obligatory. Which rules are obligatory in the sense that if you don't comply with them, there should be consequences, right, within the societal setup. and which rules are, if you like, it's quite gentlemanly. It's quite nice to obey them. Although if you don't obey them, there will not be any serious consequences within the societal setup. But just out of courtesy and things like that, you obey them. So Hart makes a point that it gets to a point where it becomes uncertain to know which of the primary rules are really obligatory and which ones are non-obligatory. So that is one defect you see in the primary rules as society becomes a bit more complex. The second defect, which Hart'S are noted as being discernible as society becomes more complex, it has to do with staticity. That is to say that the primary rules become somewhat static. Static in the sense that the primary rules will just be lagging behind so many social practices which have changed, so many precepts which have become part of society. The primary rules may be lagging behind them. So there's that kind of a staticity. It's static, it's not flexible, it's not dynamic. So there will arise the need to change the primary rules. And then Hart identifies the third defect in the primary rules. As society moves from a simple society to a complex society. And that defect is what he calls inefficiency. And what does he mean by this inefficiency defect of the primary rules? Hart means that you begin to see that there is something missing. And what is that missing? That which is missing is that you don't have any arrangement, any system for making a determination as whether a person's conduct or omission complied with the primary obligation or violated the primary obligation. So there'll be the need to adjudicate on breach of primary rules and administer the primary rules. So these are some of the defects which you begin to see as society moves from being simple to a complex society. Now, Hart makes a point that in order to remedy or in order to correct these defects in the primary rules, as society becomes a bit more complex, there's a need to have another category of rules, which he calls the secondary rules of what? Obligation. And these secondary rules of obligation are introduced to signify a step from the pre-legal order to the legal order. Now, when you get the secondary rules of obligation, according to Hart, what it means is that society has now entered into the legal order, because the primitive society was what you call the pre-legal order, because over there, you had only one type of rules. That is the primary rule of obligation, which tells us about conduct, which is prescribed, and conduct, which is not prescribed. But as you enter into a more complex society and then you adopt the secondary rules of obligation in order to remedy or correct the defects of the primary rules, society will have entered into another phase. And that is what you call the legal order. Now, what are some of these secondary rules of obligation? He mentioned a rule of obligation. So let's say a few more words about the rule of obligation. Now, the rule of obligation is introduced to address a specific defect in the primary rule. And that defect in the primary rule, which the rule of recognition seeks to correct, is what we call the defect of uncertainty. The defect of uncertainty. Now, as you remember, we said that it will get to a time that you are not clear as to which of the rules are really obligatory, which of the rules you don't have a choice as to whether to obey or not to obey. Now, the rules of obligation is introduced to help address that, to ensure certainty. So Hart will make the point that it's essential to the existence of a legal system, right? That is, you have the rules of obligation or recognition, which will spell out the criteria by which validity of the rules of a legal system is determined. I give you an example. In Ghana, I've mentioned Article 11, right? The source of laws in Ghana. And then when it also comes to, let's say, customary law, for example, right? Customary law, that is another typical example where we can illustrate this point. You notice that as a result of the colonial background, if we look at the Supreme Court Ordinance of 1876 and the case of Angu versus Atta, there used to be the saying that a rule of customary law is a question of fact and not a question of law. And for that matter, if someone was asserting something to be the customary law, he had the burden of proof on it, and he had to marshal evidence to prove it like any other allegation of fact, and so on and so forth. Of course, that is no longer the law. Having had our first Republican Constitution, and now we have the Courts Act under the Fourth Republic. If we go to the Courts Act at 459, question as to existence of customary law, not a question of fact, it's a question of law. What that means is that it is the duty of the judge to actually determine as whether it is really part of our laws or not part of our laws. But that aside, you still look at the Courts Act, and I think if you look at the section, I think 54, 55, 56, we have a procedure regarding how you make a determination as whether an alleged rule of customary law is really customary law or not. And remember the case of Bila and Salifu, a very old case, Bila and Salifu. Do you remember that case? Do you remember Bila and Salifu from your legal system? Or from criminal, yeah. Or from, yeah, Bila and Salifu from legal system. Remember that? Okay, so I mean, it was about this dispute as to whether among the people of Dagomba, where someone is alleging that someone had sex with his wife and so on, who actually would take the compensation, what do you call it, the vagina money? Is it the person whose wife had been defiled, or it is the chief of the people who is going to take the compensation, so-called vagina money? So Bila and Salifu, 1971, 2 Ghana Law Report 87. We had Taylor J, as he then was, who actually went to town to try and determine what the true legal position was as far as who was entitled to what you call the compensation for defilement of a wife of another person was as it were. So you can look at it, but not so much about the fact, but as to the legal processes, especially in trying to determine whether a certain position of the customary law of the Dagomba people, which was being asserted, was actually true or not. Okay, so somebody is saying that I should provide the citation. Okay, let me put it in the chat here. Bila versus Salifu. 1971 to Ghana Law Report 87. Yeah, I think you can see it over there. Okay. Yeah, so the rules of recognition, as I said, will help us to determine validity of rules of a legal system. And I just mentioned our own Article 11 as an example. And then I just cited the case like the Billa and Salif in relation to judicial ascertainment of alleged rule of customary law. So this rule of recognition, Hart is saying, was introduced to rectify or correct the defect of uncertainty in the primary rule. Maybe just a single rule or set of rules. So maybe it can even be the Constitution. And as I said, the Constitution of Ghana, for example, could be said to be an example of a rule of recognition. If anybody or anything is laying claim to be part of the laws of Ghana, and if it's not compatible, right, if it does not sit well with the letter and the spirit of this Constitution, then that is not part of the laws of Ghana, as it were. Or if you wanted to have a more specific, a poignant example, then Article 11 that I mentioned, that can be, if you like, the rule of recognition, as it were. Another secondary rule, which will be introduced as society becomes complex, is the rule of change. And the rule of change is introduced to address or correct a particular shortcoming or defect of the primary rule. And what is that? The static nature of the primary rule. The staticity that we talk about, the fact that the primary rule may not actually grow fast enough to reflect changes in society and so on. So you have the rule of change, which will designate individuals or entities who have authority to make changes in the primary ways. I mean, in the primary rules. So, for example, if you come to Ghana, right, even our Constitution, the Constitution itself, right, the Constitution itself, we have like a whole chapter which actually tells us how you may make changes to the Constitution. So if you look at chapter 25, right, chapter 25 of the 1992 Constitution, it gives you an example of like the rule of change. So the Constitution itself, which is even like the highest law, there's a way of what? Of changing it. Then we also have the rules of adjudication, right? The rules of adjudication. And this rule is also introduced to remedy the defect of inefficiency in application of the primary rules. And as we said, what is that inefficiency? There was no system to help us to determine whether the primary rules of obligation have been complied with or have not been what? Comply with. So you need another set of rules which will designate officials who decide disputes authoritatively. And so like the court system and so on. So I mentioned that you get like the court system, know how a court is set up, who qualifies to sit on the court. You get the powers of the court, jurisdiction. You get procedure, which should be followed in order to bring a case before the court. and so on and so forth. You get the set of rules which actually determine how a person may establish allegations before the court and all that. So all this will constitute the rule of adjudication. And as you notice, they are addressing a certain defect, that is the defect of inefficiency in application of the primary rules. So therefore, how to make the point that if we are talking about law, law is the union of primary and secondary rules. So mind you, Hart is not saying that law is a command backed by sanctions. No, he's saying that law is actually a matter of rules. And there are two major categories of rules, the primary rules and then the secondary rules. So secondary rules of recognition, secondary rules of change, secondary rules of adjudication. So these rules, together the primary rules, will give you what we call law or legal system, according to Professor Hart in his concept of law. So let us keep that in mind. Certainly, no legal theory is without limitation, and legitimately so. Some criticism have been leveled against H.L.A. Hart in his concept of law. And one of the criticism made against Hart'S has to do with the fact that the central set of elements constituting an official acceptance of the rule of recognition is problematic. The rule of recognition, like, for example, the Constitution, right? So if you take Ghana's Constitution, for example, let's take Article 3, right? Article 3 is about the defense of the Constitution. That if someone attempts to overthrow the Constitution, we are encouraged to do all that within our power to resist that, including even taking up arms, so long as it's going to lead to the restoration of the Constitution and so on and so forth. Now here, there is a problem, and the problem has to do with the moral acceptance of whatever you're calling the rule of recognition, because the rule of recognition also brings back the question of what we are trying, legal positivists are trying to run away from. That has to do with the bringing morality into law. Because if you take the Constitution, why will you say that the Constitution is the ultimate criterion? You certainly point to the fact that we as a society entered into certain agreements to adopt the Constitution. And that fact is actually recited in the preamble, isn't it? When also, was it the 28th of April, 1992, we line up in a referendum to go and vote yes or no for the adoption or rejection of the Constitution. And then the overwhelming majority voted yes, so the Constitution was also adopted. So one will argue that we as a society have actually agreed to have the Constitution, and for that matter, that becomes, if you like, the basis of legitimacy. Now, that kind of thinking is also going into some realm of natural law thinking, as we have actually seen, when it especially comes to the social contract theory. So the morality dimension, which legal positivists are trying to run away from, actually come to what? Meet it again. So that is another challenge. Again, if Hart'S is taken at face value, the point of the rule of recognition, which we identify as a matter of empirical fact, is to cure the defect of uncertainty in a society of primary rules alone, as we have noted. And it follows that any rule purporting to be a rule of law can be identified with certainty by applying the test of identification of the rule of recognition. And it follows further that any rule purporting to be a rule of law that cannot be identified with certainty is not a rule of law at all. But that is a problem because what we call like the hard cases, later on when we come to talk about the Ronald Dworkin, probably like in the second semester, no, the what we call like the hard cases, that is the hard cases, those cases in which it is controversial what the law is, the applicable law is not so certain, it's not so straightforward. I have referred a group, for example, to certain cases. For example, the Ray conjoined twin case. I think a group is working on that. The separation of the twins who were conjoined at the pelvic and so on and so forth. And as to when there was this issue, if you decide not to conduct the surgery, over time, both will probably die. You conduct the surgery, one will die. So are you going to conduct the surgery and kill one? Will you be committing the offense of murder or manslaughter, and so on and so forth? So if you like, it's a sort of an example of a hard case where what the law is not really straightforward, so to speak. But what also happened is that if we look at all the so-called hard cases, which come before maybe appellate judges or judges, in the appeal court, the Supreme Court, and all that, it's not all the time that is really about what the law is. There may even be times in which it's about the proper finding of evidence or proper application of evidence rather than dispute as what the particular legal position should be. Okay, so Erica, okay, now they've presented, okay, that's fine. Good, so at this point, I will pause and take questions before we continue, or contributions.
Hello, Doc.
Yes. Yes. Yeah, let me hear you.
Sorry to take you back. In fact, my network was disturbing me, so I couldn't get the last bit of the criticism of Hart'S.
Yeah, I think it had to do with the, the point he makes about the rule of recognition, and we're trying to say that if we read his work, he like Joaquin, they talk about how they call like the hard cases, and then the hard cases being those cases in which the legal position is not supposed to be clear. We don't know clearly what the law is for those hard cases, and we're making the point that even the so-called hard cases, where he thinks that the rule of recognition probably will have done the magic, is not all the time that if we look at litigation and cases which make their way into the the appellate courts, the worry is so much about the legal position not being clear, as it were. And sometimes what will actually go to appeal will be maybe misunderstanding as whether the trial court made a proper finding of evidence, a fact, whether he made a proper finding as to certain things as having happened or not happened, or sometimes about proper application of the law to the evidence, and not so much about whether we don't know what the law is. So that is the point I was trying to make. And there are so many other criticism that you can level against Hart. But the point to note is that the attempt to explain the nature or essence of law, which is the burden of all these jurists, all these legal philosophers, is not something which can satisfactorily be, if you like, responded to by any particular scholar. So therefore, no matter how attractive a particular scholar's responses, you may still get one or two shortcomings, and it's quite normal. It's quite normal. There's no flawless concept or theory. Yes. Yeah, Kofi, please go ahead. Kofi Asantianin.
Yes, Doctor, good evening.
Good evening.
When you, yes, on rule of recognition, when you read Kelsen's theory on grand norm and other
Hart'S or
positions,
we haven't done done Kelsen, so
yes.
So let's talk about
yes,
Hart'S. Do you understand?
Yes, on Hart'S, I wanted some distinction between the rules of recognition from Hart'S to that of Kelsen, but perhaps you said we'll come to Hart'S.
Yeah, we are going to have Kelsen
after
Hart'S. So when we've done Kelsen, although I know that when we did constitutional law,
yes,
the case of Salah versus the Attorney General, the case of Michel versus DPP, the case of Espati Matovo, the case of Ladna Beck, you were supposed to have encountered Kelsen's theory on pure law and the so-called Grunom. Yes, but we will come and discuss Kelsen after Hart'S. So maybe when that is done, then we can do the two.
A better comparison.
Yes.
Yes. Thank you very much.
Pleasure. Who else? Okay, then.
Hello.
Emmanuel.
Hello, sir.
Yes.
So please, a big clarification concerning the background or the basis upon which Hart'S developed this theory of law concerning the human nature being vulnerable, soft, and also resources being scarce, which requires the need for law in order to protect human beings and these resources. Please, how is that different from the Hobbesian conception of human nature in the state of nature, where he talks about human being vulnerable and also requiring the social contract for the sovereign to protect the human society? How do we reconcile these two theories? Thank you.
Okay, all right, thank you. Good. So if you take Hart'S work, later on there's something we call like the Hart-Fuller debates, okay? And initially Hart was very strict positivist, and he made no accommodation for any issues of morality and so on and so forth. But then after the Second World War, the post-war trials and a very unsatisfactory straightness in applying the law, the positive law, and so on, brought about a debate in terms of the relation between law and morality. And later on, Hart will come to make a concession that you cannot ignore morality completely because of human vulnerability. And what are those limitations in human beings which make it necessary that it should not just be strict fidelity just to the law, but in some contexts, we must also, if we like, accommodate certain involvement or, if you like, issues of morality at some point. So it was in that context that he identified those limitations that we've talked about. It's not the case that he did any empirical, if you like, research and he made those diagnoses, but it was his reflection on his own initial fidelity or his strict adherence to a positive law and his complete rejection of natural law ideas and also even like the command theory and so on. Now, when he reflects on all that and things which have happened, then he realized that it may be going extreme to completely ignore the possibility of the role of morality in, if you like, certain things about the law. That is where. So if you look at the book I put on your platform, just a minute. The book I put on your platform, you will notice that in the chapter, I think the very last, I think to the last chapter, that is where he will come to make those concessions. I think that's the chapter 9, chapter IS, when you talk about laws and morals, okay? So if you go to the page 185 to page 200, Hart'S will be talking about the minimum content of natural law. So the minimum content of natural law is what actually led him to those things that we said. But initially, he was not prepared to entertain anything, what the natural law people say. But as I said, after the Second World War, the various trials, and also the Nazi, Nazi war criminals which were being tried, and the woman who had also denounced the husband had actually gone to divulge his conversation with the husband to the Nazi regime, leading to the man arrest and all that. Later on, when we discuss the Hart'S debate, we come and talk more about this. All those things shape Hart'S view and made him make some concession to natural law. Yeah, so that is it. But you can look at chapter 9, that the laws and morals in the concept of law, in order to read more about this.
Hello, sir.
Yes, Davis.
Yes, sir. So my question has to do with Fuller in relation with, even though he's a natural law jurist, I find some of his work in tandem with the positive law, and I want to clear my confusion.
Okay.
As to how he's entirely a natural law jurist, because if you read about positivism, it's about lay down rules. If you, the Latin word is ponere, meaning lay down rules. And if you read Fuller's law of what do you call? Law of moral, about how laws ought to be made. Laws are not to be made and kept in a room which the people will not know about it. The law does not ought to be contradictory. The law must be like in the same vein as Article 106 of the Ghanaian Constitution, meaning something that is laid down for everyone to see. The law has to be known by the people. So situating the argument in this line, even though if you read his debate with Hart, he said every law has to be supplanted with some kind of morals. So I kind of get his moral aspect, but I don't know how, if he's arguing for laws to be made in orderly manner, like how positive law jurists are arguing that law should be made in lay down rules that everybody should be aware of it and stuff. How is he entirely a natural law jurist than a positive law jurist? That's my question, sir.
Okay, all right, Davis, thank you. Yeah, so let's be clear here. Fuller is not positivist. Fuller is a natural law jurist. And his natural law is labeled procedural natural law. And as we explained that Fuller was concerned about we seeing morality as embedded in the processes, the manner or the ways in which law is even made, that within that itself there is the idea of morality already embedded in it. And for that matter, if you have any law and that law, for example, does not reflect the embedded, or what we call like the inner morality, right, of lawmaking, then that law is not law, or is not like a good law. Now, it does not mean that makes Fuller a positivist, because here he said that even if you are the lawgiver and you have given the law, and the law, we examine it, does not reflect the inner morality in terms of the canons, the good principles, which must be reflected in any law, such as, for example, the law not imposing burdens which cannot be carried out, the law being made known to those who are supposed to be governed by it, and so on and so forth. Then the law that we have made is not good. But the positivists, they were, as we'll be talking, they make the point that all that matters is that the law has actually been put forward or has been made by a person with authority to make law. And again, you made reference to the 1992 Constitution of Ghana. Now, let me quickly say that the 1992 Constitution of Ghana reflects the best, the best features of both natural law and legal positivism. So the Constitution of Ghana and Ghana legal system, you cannot just say that it is just endorsement of legal positivism. No. And neither can you say that it's a just endorsement of only natural law school. In my view, you can get enough material from the Constitution to illustrate both natural law thinking and also legal positivism. We cited the fact that natural law is teleological. Natural law see law as having a purpose, society as having a certain ultimate goal, and so on. Now, if you take the Constitution of Ghana, we cited chapter 6, right? Chapter 6 of the Constitution, the directive principles of state policy. We also have even the preamble and all that. And all these things are actually telling us that we, as a Ghanaian society, we have a certain purpose. We have a certain type of society vision that we want to achieve, and so on. And not only that, then if you also want to think strictly legal positivism, we have the people who make law, right? Law is Act of Parliament is actually enacted by the president and then the parliament. So you go to Article 106 of the Constitution, the procedure for lawmaking is actually there. So one will argue that once that procedure has been activated, then that is the law. But the good thing is that if you go even to Article 106 of the Constitution, it is not fully legal positivism. There is an embedded in it some natural law ideal. Because if you look at Article 106, all right, Article 106, for example, there's a reference to, let's look at the 106 clause 2, for example. Let me quote that. No bill other than such a bill as is referred to in paragraph A of Article 108 of this Constitution shall be introduced in Parliament unless A, it is accompanied by an explanatory memorandum setting out in detail the policy and principles of the bill, the defects of the existing law, the remedies proposed to deal with those defects, and the necessity for its introduction. And B, it has been published in the Gazette, at least 14 days before the date of its introduction in Parliament. Now, if we look at all this, you notice that it's not reflecting just legal positivism. There's also a natural law dimension. We even see aspect of Fuller here. Fuller said that the law must be what? Published. It must give publicity to the law. It must give publicity to the process by which the law is made and when the law is actually made. Now we have told that it should be gazetted. Now we're also being told that you should let us know the purpose for making that law, and that is going to also serve as an important principle in trying to interpret the law, and so on. So my answer to Davis is that we cannot say that Fuller is legal positivist just because he says that if you look at how positive law is made, or how law is made, there are certain embedded morality, what they call like the inner ought morality, and for that matter, is the same as the legal positivist. Yeah, so that is what I would say for now. I don't know if anybody wants to add to that discussion. Otherwise, you will move on to Kelsen before we end jurisprudence and see what we'll do next. But before we go to Kelsen, class rep, the group, where did I end when I was giving like the
You ended at group 7.
So what it means that group 7, up to group 7, they all have something to do, is it?
Yes, and they've
Okay, yeah,
presented
okay.
it.
Yeah, okay. I'm not talking about I'm talking about the second set of work.
Okay.
I'm talking about the
Oh,
one I
you-
gave on positivism. Which group did I give up to?
You gave up to
Six.
6.
Up to group 6. Okay. All right. So group 7.
No. No.
Then gave up to 5.
Group 5. Okay. All right. So all right. So we have up to group 5. Okay. Now group 6. Just a minute. Group 6. Please, the concept of law that I have put on the platform, you are supposed to take chapter 1, right? You are supposed to make a presentation on basis of chapter 1, just the same instruction that I gave the other group. So chapter 1 is about the persistent questions. So just about 13 pages. It's not anything long, okay? Then group 7, you are to take chapter 2, laws, commands, and orders. Also, not anything long you should worry about. But because it's not long, I would like you to add group 7, you take. No, I think let me make it a bit fair. So please let me correct myself. Group 6, take chapter 1 and 2. Okay. Persistent question, and then chapter 2, laws, commands, and orders. So that is for group 7. Sorry, group 6. Class rep, please capture it for me.
Yes, sir.
Okay. And then group, is it group 7 now?
Doc, please correct
Yes,
me.
group 7.
Yes, please do.
Please, group 6, we presented the in-reconjoint twins.
That
It's
one,
been done.
no,
No.
that one is different.
There's a new assignment.
Yes, there's a new assignment. Thank you. That's right. Okay, so group 7, please, you are doing the variety of laws, the sovereign and subject. So that is you are taking chapter 3 and chapter 4.
Variety of laws.
Group 8, you are taking chapter 5 and chapter 6. And group 9,
Group 8.
yes, they are taking
Chapter 5.
and chapter 6. Law as a union of primary and secondary rules. And then chapter, no, which group is doing chapter 3 and 4?
Group 7.
Okay, so group 8 is doing
Group 7.
So group 8 is doing chapter 5 and chapter 6. Then group
Yes, sir.
9 is doing chapter 8. Sorry, chapter 7 and chapter 8. Then group 10 is doing chapter 9 and chapter 10. How many groups are you left with?
1 for jurisprudence.
Okay, so when we go to Hans Kelsen, then we give them their work there. So let's, yes.
Doc, respectively, chapter 3 is almost 16, 17 pages. So the variety of laws, I think it's very relevant.
You say it's what, chapter 3?
It's almost 17 pages.
Okay.
Yes. The variety of laws. It starts from
Yes.
from page
Yes,
37.
I'm aware.
And you'll be ending.
I've been working on this document with
Okay.
different groups of students for more than 15 years.
Oh, yes, sir. Yes.
Okay.
Thank you, sir. I wanted to try because you said the chapters were too short. That's why I wanted to know.
Oh, no. Okay, all right. Thank you. Okay, so please, let's quickly, I want us to end with the Kelsen and then we stop jurisprudence for tonight. Okay, so let's discuss Hans Kelsen's pure theory of law, or his contribution to legal positivism. And thank God, because of constitutional law, a good number of you remember something about Hans Kelsen, which is very encouraging and quite welcoming. Now, Kelsen, Hans Kelsen, as we know, was an Austrian-American jurist. And he lived between 1881 and 1973. That's a very good old age. How many years is that? What was his age? Oh, our math teachers are not there.
92 years.
92 years. Yeah, see
so.
how sometimes devoting yourself to thinking and learning can let you also live a bit longer on this earth. Yeah, so Kelsen was very committed to the cause of legal positivism. And what he sought to do was to actually do a work which we call the general theory of law and then the pure theory of law. And Kelsen represented a legal system as a complex series of interlocking norms. No, you know, if you say like interlocking norms, no, like just like if like the chain connected, you know, interdependent, which progresses from the most general norms or oughts to the most particular or concrete. So he thinks that a legal system, and that is why, if you remember the constitutional law, when you're being taught the Solicitor General, we said that and Kelsen will present the legal system as an inverted pyramid. You know how pyramid was? Looks like, of course, thank God, I had the privilege this summer of going to Egypt, and I actually visited the Pharaonic pyramid, and I saw how it is. But I mean, still in drawings, you know, you can have an idea of like the pyramid looking like a bit like like a triangle sort of, you know, as it were. But Hans Kelsen would say that the legal system, if you like, is like an inverted, that's like a reversed pyramid. You know, which is said that it starts from like the general norm or ought to the most particular or concrete, and that each norm interlock, or it's intertwined or related with the other. And what does Kelsen mean by norm? And please, just remind you, pay attention to the evolving terminology. When we go into legal positivism, you notice that Bentham and Austin, in trying to explicate their theory, they use words like command, right? They talk about like command. Now, Hart'S comes onto the scene, and then Hart'S makes a change. Hart'S does not say command. Hart'S uses the word rules, if you are paying attention. So Hart'S will say that for him, law is a union of primary and secondary rules. So he's using the word rules, he's not using command. Now, please, whoever has the children talking at the background, please mute yourself. All of you mute yourself. You unmute yourself only where you want to talk in the class. Otherwise, only my mic should be on because I'm the one doing the talking now. If you want to talk, you unmute yourself. When you finish, you mute yourself. Thank you. Now, Kelsen is not using rules. He's using another language, norms or ought, right? Now, Kelsen makes a point that norms means a rule. And he describes norm as a standard by which human conduct is supposed to be measured. So like that for him, like meaning that like he's using norm as a rule. So if you see norm, he means a rule. And by that he means the standard, the yardstick by which you measure a human, by which you measure a human conduct as it were. So the law consists of norms used as a specific social technique by politicians to determine how individuals ought to behave so as to promote social order and peace. So, Kelsen is trying to understand the legal system, how society functions. And he said that you can see law as being a specific social technique, which political superiors or those who have political authority, they use to actually control or dictate how people should behave in order to ensure social order and peace. And how does this work out? According to Kelsen, this technique consists in the acts of will of individuals authorized by law to create norms which render behavior of individuals lawful or unlawful, providing sanctions for failure to comply with the norms. So those who have the power or who are given the power to act, they indicate how people should behave. And if people don't behave according to how they want them to behave, then they have the power to visit sanctions upon them. But Hans Kelsen makes a point that norms are not the same. We have legal norms and non-legal norms. And for him, legal norms differ from other norms in that they prescribe a sanction. So here, see how it's going back to some of the early positivist thinking. Some will say that it's a command backed by sanction. But now he is saying that for him, law is a norm backed by what? A sanction, if you like. So legal norms prescribe a sanction. Non-legal norms do not prescribe a sanction. So you give like a typical formula or illustration that if condition S exists, then legal consequence Y should apply. So that is the kind of legal norm he's talking about for purposes of law. That the public official or the authority who has the power or who has been given the mandate to do certain things. This is how he functions. If condition S exists, then legal consequence Y should what? Should apply. So therefore, in Kelsenite thinking, a norm being a prescriptive statement means that what should be done or what you should do is incapable of being true or false. It can only be valid or invalid. So look at it. So he is moving away from some of the claims of legal positivists. And he said that there's nothing like having the norm as being true or false. No, it is either valid or not valid. So now he's still going back to what we call like the source argument. The source argument means that what is the source of that norm? Who prescribed that norm or the ought statement? Who prescribed it? If the person can trace his authority to the most general norm, the most basic norm, or what you later call the true norm, then it is valid. So for a norm
Hello, Doc. Hello, Doc.
Yes. Sammy?
Yes, sorry. Yes, we couldn't hear you.
Hey, so I'll be talking to the, wow. After where?
Yes. From where we talk about true or false.
Oh, wow. Sorry. Okay.
I even have, I had something to ask there.
Oh, right. Okay.
Yes, yeah, the bullet 6, where you talked about a norm being a prescriptive statement.
Prescriptive, yeah.
Yes, incapable of being true or false. The false, Are we talking about?
No, I'm talking no, not false as in like is a as opposite of true, is a typo.
Oh, okay.
It's a typo, it's a typo, typographical. Like false as in falsity, like opposite of truth or veracity. Yes. Yeah, thank you.
Okay.
Yeah, so we made the point that according to Kelsen, a norm cannot be true or false. Rather, a norm may be valid or not valid. And what does it mean by that? He has already made the point that law or legal system is, if you like, a set of norms or oughts which interrelate or which are interlocking. And he makes the further point that for a norm to be valid, that norm must actually derive its validity from a higher norm. And I explained that within a legal order, within a legal system, each norm, right? Of course, if you come to Ghana, maybe if you wanted to be very, let's go to the entertainment sector. I think there's a song they call Obia on the Master or something like that. You know that one? There's one track, Obia on the Master or something like that.
Obia on the Master.
Yeah, Puno.
Yes.
Yeah,
on the master.
Okay, good. Now, so that literally means that each one has got someone higher than him or her. So transposing that into Kelsenite thinking, that if you take the legal system, he said that the legal system is made up of norms, and the norms are the ought statements, which prescribe the conduct expected. And if the conduct is actually not met, then sanctions are applied. Now, each of these norms, each of these ought statements, they have ought statements or norms which are higher than them. So that is the point he's trying to make. And you can keep tracing until you get to, if you like, a very last or the highest norm. Yeah, so that is the point that he's making. So therefore, a norm is authorized by another norm, which in turn is authorized by what? A higher norm in the system. And this happens either by the lower norm's content being in conformity to the higher norm, or by the higher norm authorizing the creation of what? Of the lower norm. So let me give you an example. So probably if you take Ghana, let's suppose that maybe the place that you live, the district assembly or the metropolitan assembly or the municipal assembly, they have a certain bylaw, or they have there's a certain directive that do this or don't do that. Maybe pay market toll or pay business operating permit and so on. Then you want to ask, what is the source of authority of this? Then it will take you back to, let's say, a certain bylaw, which KMA or the Bosomtwe district or Ejura or whatever a district assembly pass. And then you ask, what is the source of authority of this bylaw? What gave these people the authority or the power to make this bylaw? Then let's say that you trace it back to the Local Government Act, okay? The Local Governance or Local Government Act, which, for example, enable the sector minister to probably prescribe, legislative instrument to set up a particular place as a district assembly and so on and so forth. Then you ask, what is the source of this authority of Local Governance Act, giving power to the minister to make LI, to set up a municipal assembly or district assembly, metropolitan assembly. Then you'll be told to Parliament that this was made by Parliament. Then you ask the question, where did Parliament derive its authority from to make this Local Governance Act? Then it takes you back to the Constitution of Ghana. Then you ask the question, what brought this Constitution into being? What makes this Constitution the source of legitimacy for all these norms and all that? So you see how we are trying to trace the validity of one norm to the another. And each norm has got a successive or succeeding, what do you call it, the higher norm. So that is why I cited the Yapunu song, like Ubian in the master sort of thing. Yeah, so you notice that within Hans Kelsen's thinking, there's a clear separation between law and morality. And that means that the validity of legal norms can flow from only another legal norm and not a moral norm. So if you look at the illustration that I gave, you notice that the validity of whatever action or whatever law which I pointed to was traced to another law, or if you like, another norm, and not any general moral principle, as it were. So that is the point we are trying to make. Now, in trying to trace validity of norms, you come across a hierarchy of norms, because if we make the point that each norm is authorized by a higher norm, then that presupposes that we have a hierarchy of what? We have a hierarchy of norms. If you say hierarchy, that is, we have a structural arrangement of norms from higher to lowest, or from lowest to higher, as it were. So some form of hierarchy. And the hierarchy of legal norms, which forms a legal system, is ultimately traceable back to what we call the Coup norm, or the basic norm of the legal system. So if you keep tracing, just like the one I attempted doing with the local government thing, from the district assembly right up to this, up to this, up to that, you get to the Constitution, and then you also go back, the Constitution. What is the source of authority of the Constitution? So you trace until you get to the what Kelsen called like the Coup norm. That is the ultimate, the basic norm. You get there. And I'm sure that when we learn constitutional law, especially the constitutional, the legal effect of coup d'etats and revolution on the pre-existing constitutional order, you came across some of these ideas. So what is a Coup norm? The Coup norm, or the basic norm, is a norm which sits atop the hierarchy and is the common norm of the legal order. So the Coup norm is, if you are at the very top, which keeps giving validity to all the norms within the succeeding hierarchy, as it were. And all norms in order to constitute a single legal order must trace its validity along the hierarchy to the same basic norm. So he sees, if you like, a law as having a linear or having a vertical, like just like a straight line. It's like one order. And each norm or each ought, each prescriptive statement along the continuum can derive its validity from the succeeding one, and then until you trace to the very first one, if you like. And that is why it is a single legal order. Now, you may want to ask, this group norm, what is it? Well, Kelsen will say that when you keep tracing validity of the succeeding norms until you get to the group norm or the basic norm, where you reach there, you cannot trace validity of any norm further. Once you get to the group norm, then you've hit the end of looking for validity. That is the end of things. And you cannot trace validity of the basic norm or the group norm to a higher norm. There is no norm which gives validity to the group norm. Because if that were so, it will defeat the logic of Kelsen's theory that once you keep tracing validity of the various norms and you get to the group norm and you've reached the end of the search, if the group norm must also get its validity from another, then I mean that would be illogical to Kelsen's theory. And that is why he says that the validity of the group norm is presupposed. In other words, we presume or we assume that the group norm is valid. So you don't actually make effort to find out that which gives validity to the group norm. You presume its validity. And from the group norm downwards, it gives validity to all other descending norms, as it were. And Kelsen makes the point that you cannot have more than one basic norm or one group norm within a legal order, because all norms of a particular legal order must be traced to the same single basic norm. So in any legal order, in any legal system, and so on, you have only one group norm and not two. Now, the basic norm or the group norm, unlike the lower norms, is not created by custom or legislation. And we've made the point that its validity is what is presupposed. Its validity is actually taken for granted. We presume that it is valid. And for that matter, we cannot say that it was created by custom or legislation. And again, the group norm is not chosen arbitrarily. It is selected by reference whether the legal order as a whole is by and large efficacious. In other words, in trying to find out what the group norm is, you must ask the question, if you look at the legal order in totality, can we say that it is efficacious in reference to what you are trying to call the group norm or the basic norm? And by efficacy here, we mean that do people within the legal order, do they obey the various norms which trace their validity ultimately to what you are trying to call the group norm or the basic norm? Now, this is where the effort by scholars or jurists that try to explain the legal effects of coup d'etat or revolution on pre-existing constitutional order becomes handy. And here, you remember the so-called Salah versus Attorney General, or you get those cases where you have a military intervention, they come to overthrow the constitutional order. Now they set themselves up as the new, they set themselves up as like the new authority, right? And oftentimes they have what they call like the proclamation statement or decree or proclamation instrument. So question may arise. Now, what happens to legal arrangements which were in force before the junta, the military government, for example, came onto the scene? So that is the context of the, if you like, the Salah, and then the case of Michel against DPP, and then the case of S-Party Matobo, and then the case of Mazimabutu against Ladnabek. Those are very interesting cases. And argument to be made that if the military junta, for example, by their proclamation statement, the authority is accepted, and from that moment going, all other things which are supposed to be law are obeyed, and they trace their validity or their force or authority to the power of the military junta, their proclamation. Then the proclamation, as it were, become like the basic norm or the glue norm. And within Kelsen thinking, you don't question the legitimacy of the basic norm, in this case, the proclamation by the military, as it were. But of course, if you look at Ghana's constitution, especially in terms of Article 3 of the constitution, as well as Article 1 and 2, one will actually disagree as whether we can use Kelsen's theory to justify any coup d'etat which may be made to put in place a military government, because Article 3 actually seeks to empower people to resist any overthrow of the constitution. So you look at it right from the word go, the legitimacy of any coup d'etat revolution is a suspect in terms of the letter and spirit of Article 3 of the Constitution, as it were. Now, the GRU norm has two functions. One, it confers law creating power on the act of the first legislator within a legal order, and all other acts based on the first act, thus making it possible to regard a coercive order as objectively valid. So that is what the GRU norm does. Like, because it's the primary norm, whoever is first to be seen as like the person making the law, his authority is traced to the GRU norm. And all those who are under him and successively, whatever they are doing, its validity can be measured according to whether it is traceable to this, if you like, a first legislator who in turn derive his power from the GRU norm. And two, the GRU norm provides an explanation for the coherence and unity of a legal order. So if you have any legal order, maybe like our legal system, if you want to understand how the system is and how things actually fit into each other. As Kelsen will tell us that the GRU norm will help provide such an explanation. So let's say that the police will stop you on the road. Where is your driver's license? And then you want to find out what is the basis of his authority. Then he will trace his authority to, let's say, the fact that he has been certified and licensed and sworn as a police. They want to find out what is the basis or the power or validity for who actually certify you to be a police. Maybe you are traced to the police council. They want to ask, probably you are traced to the Police Act. Then you want to act, you are traced to probably the Constitution or Parliament and so on. Yeah, so you notice that you are trying to understand how the various components of the legal order or the legal system fit into what in each other. So in that vein, Kelsen will say that the GRU norm is providing an explanation for coherence and unity of a legal order. But the Kelsen's principle of validity of norms is limited by the principle of what they call like effectiveness. And what does he mean by that? He makes the point that the efficacy of the total legal order is necessary for the validity of the legal norms of that order. In other words, anytime you want to be sure as to whether the GRU norm and all other norms deriving their validity from it is actually valid, you must ask yourself, if you take the legal system, if you take the legal order as a whole, will you say that it is efficacious? And by efficacy here, as I have said, do people who are subjects of the legal order, do they obey, right, the various norms and so on, which seems to trace their authority to whatever you are trying to recognize as the GRU norm or the basic norm. So efficacy of the entire order is very important. So that is why people try to say that, okay, if someone has made the coup and then he gives, he's able to, stamp his authority on the whole country. So therefore, anybody who exercises authority or power traces his authority or power to him, then we can say that on the whole, it is efficacious. And this is where the case of I think the Ladner-Beck, Mazimabuto and Ladner-Beck, when there was this unilateral declaration of independence by Ian Smith, right, in the former Rhodesia, became very relevant. I don't know if you've read that case already, but I mean, the issues of efficacy of the total legal order was considered. And also, if you look at the old case of DPP and Michelle, that was also discussed as well. So let us keep that in mind. So for a legal system to exist, according to Kelsen, is not enough that the terms be valid. It must also be effective. So the effectiveness is important. It's not just the case that you can trace the various norms to the GRU norm, and for that matter, it is valid. No. Effectiveness is also what? Important. So this means that they have to form part of a system of norms that is enforced in a given place and what? And time. And a norm is considered to be effective if it is actually followed by members of the relevant community. So obedience or adherence to the norms by the subject is very important in determining whether it is effective or not effective. And again, for a legal order to be valid, it is not necessary that every law be obeyed, but that there should be general adherence to the ground norm. It doesn't mean that there's not going to be any violation of the laws, no. But we are talking about like a general acceptance of the ground norm, as it were. The ground norm in Kelsenine theory is not eternal, meaning that it is not supposed to remain in force forever. When it no longer attracts general support, it may be supplanted or taken over by some other basic norm, as in the case of revolution or coup d'etat. So you look at the Burkina Faso and the Mali and so on, there's a coup d'etat there. If, for example, by and large, the junta is able to stamp the authority and everybody accept them and so on and so forth, then one could argue that their proclamation instrument become like the new ground, as it were. But where it also backfires, and then you have like a pocket of resistance here and there, then what it means is that the junta is generally not being accepted or recognized as being, if you like, the ground norm or the basic norm. So let us keep that in mind. Well, just before we leave Kelsen, it is opposite that we also become aware of the downsides of his theory. So what are some of the criticisms which are leveled against Kelsen? Now, if you look at Kelsen's work, his initial statement of purpose was to search for an unadulterated concept of law, unadulterated theory of law. And that is why, if we look at the literature, you know, Kelsen was very careful in how he termed his theory. If you look at the original work, for example, it's a big book. If you want to read it, I can share it with you, but it's a big book. He would actually call his work the pure theory of what? Law. Pure theory of law. And that is very significant. So pure theory of law suggests that Kelsen was very concerned to make sure that he will provide a theory of law in which, right, in which you have no adulteration, you have nothing which in his view are considered impure, which in his view are considered as not forming part of what law should be. But an argument is made that Kelsen's theory is too dry, that is arid, it's unreal and far removed from complexities of law in action. That if you look at the rare situation of legal system and law in society, you cannot perfectly get what he sought to do as being the case. So that is one thing you should keep in mind. And for that matter, some critics refer to Kelsen's purpose as an exercise in logic and not in life. That is, his theory is just a logical exercise rather than a practical life thing. Now, what he's saying does not have any practical relevance, seriously speaking. If you are just looking at it as a matter of logic, it looks beautiful, but then in real life situation, things are not just that simple, isn't it? Then again, law does not, because it cannot exist as an isolate. And for that matter, it cannot be considered as such. Law can never be pure. Being pure means that you are going to purge law of all societal realities, but that is really not practical as it were, because law actually works in society. Law is from society, and law operates in what? In society. It is part of the community, and it's affected by the dynamics of what? Of society. So that is very important. And again, Kelsen's Grunom concept has been attack has been on rare, and also represent his personal value judgment investigator. Let's look at it. Can we easily recognize the Grunom? Can we, for example, even say that the 1992 Constitution of Ghana is the Grunom? Well, Kelsen makes a point also that the Grunom is not eternal, meaning that it can be overthrown. But if we look at Article 3 of our Constitution, the framers of our Constitution actually contemplate that, quite apart from we making maybe some amendments, the Constitution itself shall never be in what? Abandoned until the world comes to an end. It is our hope and prayer that the Constitution will remain. And for that matter, Kelsen's claim that where the Grunom is, for example, not serving the people, it may be supplanted by some other norm. That may not really be the case all the time. And again, Kelsen's theory appears to have said that men assume the existence of some single source when they think and talk about the law, but it does not define that source in objectively descriptive terms. If you look at Kelsen, let it appear that anytime we are talking about law, we are talking about one particular source in which all other things can be traced to. But the big question is it really the case? And is there any objective means by which you can actually establish that in real life situation? So these are some of the difficulties which we have with the Kelsen's theory. So I'll take a few questions and then I'll invite Group 10 to do a brief work. Is it Group 10 we got to? Class rep?
Group 11.
Oh, Group 11, okay. So Group 11, you will give us a presentation on...
No, sir. No, sir. Group 8 is supposed to...
It's Group 8.
So,
We
sir,
did
Group 8
Group
is supposed
7.
No, I'm talking about like the new work, not the presentations, but like, you'll be giving work to the groups. And I want to know which group.
Yeah, yes.
Yeah.
So which one?
Yes, sir. Yes, sir.
Group 10.
11, sir. 11.
Okay, so 10 and 11. Okay. All right. So I think so Group 10 does not have work. Is that the case?
But
Group 10 has chapter 9 to chapter 10.
They have.
Okay, so it's Group 11 who does not have, isn't it?
Yes, please.
Yes, sir.
Okay, so Group 11, your work is very simple. Please, you are supposed to do a presentation based on chapter 12, right, of L.B. Kelsen. That is on Kelsen. So that is your first work. Because
okay, sir.
Because the others are doing 2 chapters. Your second work is that you are supposed to, please take that down. So to what extent does Kelsen's theory of legal positivism assisted the court in the following cases? A, Salah versus Attorney General. Salah versus Attorney General. I mean, you know that case, or we have the citation already, don't you?
Yes, sir.
Okay. Then the second case, B. Don't know if you have this case, DPP and Michelle.
Yeah, we have it.
You have it.
Yes, please.
Michelle versus DPP, okay. So it's a very interesting case. Then there's this did you read the Lakami case from Nigeria?
No, sir. No, sir.
Okay. What about because Lakami versus the Western Nigeria, that is the, you haven't heard about it? It's an old
No, sir.
case. Okay.
No, sir.
Oh, but we have we have the case fully available online. So add it. I'll send the case to you. So Lakami versus Western Nigeria.
Lakami versus Western Nigeria.
Lakami. Yes, it's the Supreme Court of a Nigerian case decided in the 1970. As a very interesting. I'm sending the case to you.
Versus the Nigerian there.
I've actually sent the link to you. Yeah, Lakami versus Attorney General for Western Nigeria. It's on your platform.
Okay. I'll send it.
And I mentioned the case of the case of
be careful.
Mazimabutu against Ladnabek. Also very interesting case, 1969 case. You know it?
No, sir.
Okay. Okay.
Mazimabutu.
Yes, it's been reported in 1969, 1 AC, page 845. It's in the appeals cases, but it's also available online. It's also a very interesting case. I think I have that case. Let me also send that to you. So I'm making your life easier. You have to pray for me. I'm making life easier for you.
We are grateful.
And let me see the case of Uganda versus Commission of Prisoners, Espati Matovo. That's the last case. 1966. No, yes.
Uganda
versus Commission of Prisoners, Espati Matovo.
Uganda.
So the 1966 it's
Matovu.
very, yeah, very interesting.
Well, all these are for group 11.
Yeah, but it's part of their second question, isn't it?
Yes, sir.
Yes.
All right. All right.
Okay.
Loud and clear.
Yeah, so we will end our jurisprudence here. You're supposed to have company law. Okay, so we do the company law tomorrow evening. Okay.
Yes, sir.
All right. So have a good
Yes,
night.
sir.